Well, welcome everybody. Thank you. Welcome to the final session of the Oxford Fulbright Human Rights Seminar for 2022. And I want to thank Pembroke College for hosting me, the Fulbright program for sponsoring and making this possible, all of you for attending the speakers, the Department of Politics and International Relations, and the about half a dozen previous speakers who've come and contributed to this session. Particularly want to thank the people accompanying me today, Leigh Payne of St. Anthony's and the Latin American Studies program, and Pilar Elizalde of LSE and pretty soon the Blavatnik School at Oxford. And I'm Allison Brysk, visiting from University of California, Santa Barbara. So each of the series, we talk about the general concept and rubric laid out in my 2018 book, The Future of Human Rights, in which I tried to summarize what I saw after a couple of decades of observing human rights scholarship and where we have trends of shortfalls and where scholarship is going and where we may want to go next. And I created this dialogue to follow up on some of the key issues identified in that project and begin to update it and begin to reanimate our research agendas going forward, particularly in the wake of the pandemic and all the changes that that has brought. As well as a whole new wave of conflict in the world. So in each session, I talk a little bit about the basic framework from that Future of Human Rights book. I try to survey a little bit the scholarship in the theme area, and Annie has helped me to take the temperature of what's going on in particular theme areas. Today's theme, of course, global governance. And then I revisit a little bit some of my previous work in these areas, in some cases more distant, in other cases more recent, and sometimes it's interesting to see how things have changed. And then, of course, we have guest speakers who present their own work, and we can look across how scholarship is developing on these themes, and you can weigh in with your questions and your thoughts and things that you're observing in your own scholarship activism and presence in the world. So these are the books that I'm going to be reflecting on out of my own scholarship today, and we start with that image. So the first couple of slides are, again, reviewing and rehearsing. Fortunately, only, I think, one of you has seen one of these sessions, so I don't have to worry about too much overlap. So in the Future of Human Rights, I tried to think through some of the concept, the evolving concept of human rights, some of the evolution of our scholarly thinking about what human rights is, what it does, how it functions in the world system, and then to identify trends and gaps, which will be the next slide. So revisiting that future project in terms of what are human rights, one of the things that I concluded is that we need to think about human rights as a multiply functioning kind of concept that is at the same time a normative ethos and goal, an institutional regime and a toolbox of governance practices, a political strategy mainly employed by social movements, but also sometimes by promoter states and other international entities, and a practice that is evolving, spreading, and developing. And in terms of the formal definition, we can, even taking off from the most official and formal language of the UN Charter, that we are free and equal in rights and dignity, if we develop each of those terms, if we try to balance the free and equal and the rights and dignity, we can track the evolution of the ethos through a widening practice that is encapsulated in the conclusion of the UN at the Vienna Conference of 1994, that human rights, in principle, majority of the world states have agreed, in principle, are universal, indivisible, and interdependent. And of course, a lot of the political issues are tensions in between that aspiration and implementation of those characteristics. Also to note that as we develop our own work on human rights, we want to be conscious that in order to get beyond the thin legal regime and some of the controversies about how universal human rights can be, whether they can encompass all the kinds of equality and dignity needs, that we need to look to some feminist scholarship on rights as a kind of empowerment and not simply a legal entitlement, and look at literature on capabilities and an ethic of care, and see rights as a dynamic movement toward these aspirations. So my own formulation, in which I try to contribute to advancing this sort of understanding of rights, is that rights are not the answer, and we should stop trying to debate about whether or why they're not working as the answer. Rather, rights are the right question, and that rights are a way to orient our consciousness and mobilization and action and practice around three questions as they evolve through history. First of all, who is human? Who is included as an empowered political agent? Second, what is right? What are the standards of limitations of authority and power and of ethical practice and authoritative management? And third, who is responsible? And my contention is that most of the problematic areas in which we're experiencing difficulties are areas in which responsibilities are either ill-defined, contradictory, or not keeping up with evolving world phenomena and practices of power and authority. So in surveying the actual phenomena of human rights, I try to weigh in and transcend a bit the debate that's prevalent in kind of across the social sciences, whether human rights are an end times or a rising tide. So the very pessimistic critique, notably by Samuel Moyn, Stephen Hopgood, that we've come to an end of human rights, that human rights is kind of dragged down by its roots in the liberal capitalist Western practice, versus more optimistic thinkers. The rising tide comes out of Pippa Norris and the world values, kind of world cultures evolving, but we also have the justice cascade of Catherine Sickink, our colleague. And so my attempt to bridge these perspectives is to say that the principles and process of human rights are in fact a rising tide and continue to expand, but the implementation has contracted and new kinds of problems that we didn't anticipate have developed in the implementation. So on that positive side, we do have evolving and ever widening claims and frames for what is right, ranging from environmental justice to femicide. We have new voices and spaces. What I've highlighted, I give this overview at the beginning of each of the sessions, and then I highlight the aspects that our current issue will be developing further. So we'll be hearing about some new voices and spaces, particularly in the United Nations, new mechanisms, and that's what we'll be hearing about in terms of transnational corporate accountability. And in other sessions, we've talked about different modes for communicative action, and different kinds of coalitions that can be formed. On the negative side, on the contraction of human rights, there are longstanding gaps that have been problematized by current situations. One is the eternal citizenship gap. Who's included? Who is human? What is the state responsible for, both above and below the state? There's a security gap in terms of the state's sovereign ability to commit war crimes and other kinds of abuses with impunity. There's the globalization gap in terms of global governance, which we'll be definitely focusing on today in terms of responsibilities. There's declining democracy worldwide, and of course democracy and human rights are not the same thing, but they have been in the past associated heavily, and now that we're losing democracy, many people feel that democracy is necessary but not sufficient for human rights, and clearly when we're losing democracy, we are losing some of our ability to deal with human rights, and we'll talk about that. And we also have a kind of principled counter-cosmopolitanism with the rise of illiberal powers, challenges to global institutions, and we'll be looking at that. All right, so now a couple of slides surveying what I see as the scholarship and the literature on global governance, the issue of the day. So first of all, we simply want to note, why are we talking about global governance? What is the role of global governance in rights? Because global governance deals with economic exchange, it deals with conflict management, it deals with all kinds of things. So in rights, what we would be looking to global governance for is some or all of these things: to help to enforce international law, to help to mobilize interstate enforcement mechanisms where we are trying to break through the sovereignty barrier, to promote and expand concepts of rights or responsibilities for rights, and to fill the governance gap. And of course, we are always going to be running up against issues of sovereignty, but also this principle that starts as a legal principle and was used first very much within the European institutional context, but is now a more broadly discussed thing called subsidiarity. That is the idea that the lowest level of authority should and must deal with issues first, that you must exhaust domestic venues and remedies before you turn to global governance. We, on the other hand, I map out in the book, we have the expanding agenda and mechanisms. We have a whole set of protections now for rights defenders. We have the universal peer review process in the UN, which is what we're going to focus on later. We have increasing human rights capabilities of regional organizations, obviously the European institutions, but also the Organization of American States, and some others. And we have the growth of national human rights institutions, ombudsmen's offices, and so forth, that are linked together in a transnational network. So they're kind of horizontally across states. We have new protagonists. We have what I'll talk about in a minute, my own early work, which I called Global Good Samaritans, human rights promoter states, some states now taking a role. And there's another important scholar, Emily Hafner-Burton, who talks about them as steward states. She's a little more optimistic than I am. Then, of course, expanding responsibilities and leverage points in global governance, notably corporate accountability, a contested but possibility of responsibility to protect as a growing mandate of global institutions in conflict scenarios, and an increasingly tight web of economic sanctions as a mechanism, what in one work I called the invisible handcuff of economic sanctions. And we're certainly seeing that actually function, to my great pleasant surprise, in Ukraine. I mean, today, right? Okay, so the other part, though, of the surveying the scholarship, where are we with scholarship on global governance. This is a little dense, but I'll try to, this is sort of for everybody's reference as a resource, because we surveyed a lot of literature here. And here is, again, that implementation responsibility gap. Here is where the governance part of global governance gets tricky. So there are a couple of literature reviews that suggest we should think about this in three different ways, this problem of responsibility and the governance gap. First of all, participation. How do we get states to yield their authority, to yield their sovereignty, to participate in any of these mechanisms, international regimes or courts? And there are some somewhat optimistic possibilities that diffuse reciprocity, I mean, from the Geneva Conventions, right? Laws of war that function more than we would expect them to, because states benefit in the long run. Some states benefit in the long run from respecting each other so that in the future they can benefit. Sometimes we have, more pessimistically, but still effectively, states that are dependent upon international resources that sort of have to yield their sovereignty, are kind of leveraged into participating, and I think we'll hear a little more about that. Sometimes new democracies want to lock in their gains by yielding to an international institution so that future regimes will be brought into the process. We have debates, though, about once we get the states in, whether the process breaks down into politicization, whether states just use these institutions or mechanisms for their own purposes and don't really follow the principles. And we have some research on the UN peer review that is optimistic about that. And then, of course, what difference does this make, right? Does getting people, states, into these institutions in the long run actually influence? Does it prevent, does it provide accountability for different kinds of abuses that may take place? How much does it govern, the governance part, right? So we do have a whole variety of research that suggests that reparations can come out of global institutions, that global institutions, Beth Simmons has a bunch of interesting work that they may actually serve a deterrence role. The man at the end of the table has provided some very interesting work on dialogue and the kind of socializing and conditioning role that international institutions may play. International institutions may not have that much power on their own, but they may filter down into national courts and be domesticated and reshape that way over a long period of time. And there are a couple of things I've run across recently that actually show that international law getting countries to domestically criminalize torture and domestic violence, two very hard cases, actually reduces the incidence of police torture, Mark Berlin's work, and domestic violence, Jenny Klugman. Marginally, but still, this is promising. It's interesting. And then we've got huge backlash, right? This counter-cosmopolitanism, withdrawing from institutions, rejecting the norms, decline of compliance, politicization, and starving the global institutions. So where is the balance here? How can we do better? Let me quickly revisit some of my own work. So way back in 2000, I did a study of the rise of transnational networks for indigenous peoples' rights in Latin America, called From Tribal Village to Global Village. And there was a really interesting multi-level dialectic among indigenous peoples' movements that were not getting hearing within their own states, Some national governments getting drawn into promoting better rights, a new kind of rights for them, indigenous rights that were different than the civil political vocabulary. And these were new democracies, and they had some interest and some investment. And they were being supported in Latin America by the strength of this regional organization, the OAS. And there were UN mechanisms of the Indigenous Peoples Working Group. And there were new practices developing. And so what was interesting and remarkable about this case is that we did see the following range of norms and processes in about a decade. From the 1990s to the 21st century, it suddenly became routine for at least the question to be asked that Indigenous peoples deserve representation in international negotiations, that there's an expectation of informed consent for development projects by international entities such as the World Bank and different standards being developed. The idea that among the rights we should be looking for are land rights, that land rights are human rights, that forced displacement is not just part of the refugee regime, but that if whole collectives of people are being displaced, particularly by development projects, that is an international human rights concern. That people have, indigenous peoples have a particular right to cultural and heritage property, and that needs to be attended to by international entities. And the concept that nation states may and perhaps should define themselves as plurinational, not just multinational. And of course, all of those principles have, in the end, been limited by global corporate power, by national regimes changing. Some of the most promising cases in the Andean countries have bit by bit been pushed back in Ecuador, Bolivia. So that's one contribution that I'm following and revisiting. The other thing I did about a decade later is this Global Good Samaritans book about human rights promoter states, because I realized I needed to look more at the supply side of human rights and why any state would go against its supposed default interest in simply promoting its own national interests and actually be trying to transform the international system. Now, first of all, to recognize that there are a handful, something like, a dozen or so promoter states that have played an undue role in promoting multilateralism, that is treaties, building up regional bodies, bilateral mechanisms like sanctions, UN votes, introducing different issues in international institutions, providing peacekeeping and resources for enforcement of human rights mandates, and the promotion of new norms. And so, first of all, it was recording and recognizing. In the study, I looked at a match of the kind of typical, usual suspects, so Canada, Sweden, and the Netherlands. But then I added some non-Western, Southern, so I looked also at Japan, that was promoting the human security agenda. I looked at Costa Rica, which has historically played this sort of small but mighty role in Latin America. And I looked at South Africa with the change from sort of from pariah state to promoter state in the African context. I concluded that there is an interesting story about sort of necessary capacity and sufficient agency by these states that's based in a certain constellation of leadership, civil society, state relations, and a bridging ideology between the national identity of these states and the human rights agenda. But I noted in every case that even for these states, there is a challenge on migration. They all have better records in every other area of human rights, and that they're, like with the indigenous rights regime, that there is a constant challenge and a drift from about 2010 with changing leverage relationships and increasing backlash. What this leads me to do now is to pass over to examining, so these are two different projects that look at specific channels and agendas of global governance, their potential and their limitations, and we have such an opportunity today because we have two more streams to examine. So Leigh Payne is going to talk to us now about the sort of big question, which also articulates in both of the cases, like with the indigenous peoples, this global corporate power and the limitation of global corporate power and achieving greater global governance of transnational corporate interests and of economic actors ends up being the perpetual key question for global governance. Thank you.
Great. Thank you, Allison, for that introduction. And I'm going to touch on a number of themes that Allison presented in her framework. I should first apologize for getting here a few minutes late. I was running from a transfer of status exam, and I just couldn't get out of there fast enough. So my apologies, but I hope to meet some of you who already introduced yourself near the end. So the future of human rights is really where we have to talk about global governance and corporate accountability, because it's not there yet. So I'll talk to you a little bit about what we've found in our work. I'm going to be talking from two books. They should be in the opposite order, because the first one is Transitional Justice and Corporate Accountability from Below. That came out in 2020. And then the more recent one that came out in 2022 is more case study work on economic actors and the limits of transitional justice. So the first book is really about transitional justice, and the second one is going beyond transitional justice. Both books are built on a database that I constructed with Gabriel Pereira and Laura Bernal Bermudez, who we presented this book last week. So for some of you, this will be old, but for others, I hope it will be somewhat new. What we did was we coded every case in which transitional justice had held, the different mechanisms of transitional justice had held businesses accountable, or economic actors accountable, for gross violations of human rights. So we can go to the next. Should I just do this? Okay. And what we found is that there has been a global practice of holding businesses or economic actors accountable for past human rights abuses in situations of armed conflict and authoritarian settings, which is what we were looking at, because we were looking at transitional justice mechanisms. But this not only didn't use, but couldn't depend on any clear and enforceable international human rights laws. It's not clear and not enforceable. So much of this had to be a creative process of using what mechanisms are out there to try and hold economic actors accountable. What we see is that this means there's a kind of victims gap, where victims of corporate human rights abuses have the right to truth, to justice, to reparations, to guarantees of non-recurrence, but they don't have the systems, the international legal systems that allow them to realize those sets of rights. And what we are thinking about in terms of global governance is, why not? Right? When there's been so much achievement in terms of abuses of state actors in these transitional settings, why have those economic actors that are complicit in some of the same sets of human rights abuses not being held accountable in these strong mechanisms around transitional justice? We can think about this as a kind of gap in the literature, on one hand, that relies so much on global governance, right? The the role that international actors have played in actually extending international human rights to hold states accountable for criminal activity, for human rights abuses in the transitional justice school. It's almost unimaginable to think about international actors not being involved in those efforts to hold state actors accountable for human rights abuses. And there's also within the business and human rights field this idea of bottom-up accountability. And the bottom in this sense is foreign courts, that foreign courts should be the international actors that hold powerful companies accountable because the courts are also powerful. We wouldn't expect to see courts in the global south to hold corporate actors accountable, since they can't stand up as well to these powerful actors. But we actually find that they do. And that in fact, where the dynamism in corporate accountability, at least with regard to transitional justice issues, is in the global south, particularly in Latin America, that has played a protagonist role, and particularly in two countries of Latin America, Argentina, which is a transition from authoritarian rule, and Colombia, which is a transition from conflict. So what I want to think about with you today is, there are these few cases from the Colombian Argentine example and a smattering of other ones, but is there a way in which we could strengthen, looking at these two models, could we strengthen the global governance system that could begin to fill this victims gap and to realize these rights in countries and also regionally and internationally? So the question I'm going to ask is, what can be done? First, I'll tell you a little bit about the findings, and then I'll go into what can be done. So when I say that there's this global practice of corporate accountability, what do I mean? Transitional justice and really the creation of the international human rights system grows out of the post-World War II, especially addressing the Holocaust crimes. And we also find that at the same time, the Nuremberg trials, there were also allied country trials to hold corporate actors or economic actors accountable for those crimes, and not just war crimes, but also crimes against humanity, like slave labor in particular. So, I pictured here, because we're in the UK, I pictured the case of Bruno Tesch, who was held accountable by the British courts in these industrialist trials. He was found guilty for creating the Zyklon B gas that was used in the extermination centers, and he was found guilty and executed. We also had cases of class action civil suits in the U.S. For slave labor, mainly for Eastern Europeans who were brought to Nazi Germany and were enslaved in the industrial system. So from the very origin of this architecture of human rights, international human rights, we also have corporate accountability. We can continue that and think about the International Criminal Tribunal for Rwanda and the well-known media case where certain radio, television were held accountable for inciting genocide. Through the transmissions of broadcasts on these radio and also in the print media. There are also foreign trials that we can think of as kind of suggesting that there is international human rights law with regard to economic actors. The probably one that you might know is the case following the South African apartheid system, taking banks to U.S. courts using the Alien Tort Statute. It didn't win, but it was at least an effort to try and use accountability mechanisms in foreign courts to hold economic actors accountable for gross violations of human rights. So we've got these dramatic international cases, and yet there's widespread impunity. There are very few when you think about it. And you can ask me in the Q&A about what happened with the industrialists who were put in prison after following World War II. What happened with the Cold War? So you can say that there have been key moments in which it's been possible to hold economic actors accountable for certain types of violations in certain contexts, but this is in the context of widespread impunity. So in the idea of the victim's gap, what we find is individuals and groups have had their rights violated by economic actors. They have this rights on the books, but they're unable to realize these rights in practice because of the system of impunity. These kind of economic mechanisms for human rights, as I've mentioned before, would explain this because there hasn't been international pressure or sufficient international pressure or even foreign courts' interest to look into these cases. And it is true that in our database we find very few cases of international involvement, but when we do, these cases have been more successful. So it may be that we're confirming more the importance of these international actors. At the same time, we're saying that it can be done, that corporate accountability can be done without international actors. But we think with a global governance system, this could be a much more robust form of accountability and address this victim's gap. So what do we see as making this possible in the absence of international actors? We have a kind of metaphor of Archimedes' lever. And if you remember, Archimedes said, "Give me a lever long enough and a fulcrum on which to place it, and I shall move the world." So what we have talked about in this book is the weight that is meant to be lifted up is corporate accountability, right? How do we lift up corporate accountability? How do we make this possible? And it's especially in the context of being held down by what we call the veto power of these powerful economic actors, especially in countries, but even globally. And again, you can ask me about the veto power at the global level in the Q&A. We have weak actors, the ones who are trying to lift up this heavy weight, and those are victims of corporate abuses, particularly victims in the global South. The right tool, this lever, is institutional innovators who find a way to give voice to amplify the voices of those demanding corporate accountability and finding creative ways to get around the corporate veto power and translate these demands into realizable goals. This is sometimes the blending of domestic law, let's say labor law. I can give you an example from a couple of cases, like the example of those who disappeared from shop floors in Argentina during the most recent dictatorship. They disappear, and under labor law, Argentine standard labor law, the business has a responsibility of protecting the security of the individual on the shop floor. When they disappear from that shop floor, then this is a violation of labor law. But, of course, the statute of limitations on labor law is a couple of years, not 40 years, which is when some of these cases were moving forward through the court system. So that there had to be a blending of the acceptance that there is no statute of limitations on disappearances, combined with this responsibility of the businesses for failing to protect labor on the shop floor. So this is a creative blending of what you could call international human rights norms. There is no statute of limitations with domestic labor law. And that takes institutional innovators who are willing to think through how do we take these cases forward when, of course, it doesn't fit a traditional labor case. And I can give you some other examples of that if you're interested in. So that's the lever. And then the fulcrum is the context. So if the context is more favorable for corporate accountability, in other words, the fulcrum is closer to the weight, it takes less pressure on the part of the weak actors to lift up that weight, right? Even under the pressure of veto players. If the fulcrum, on the other hand, or the context is unfavorable and it's further away from that weight, it takes a lot more pressure to lift that up. So if we go back to thinking about the post-World War II context and the consensus, international consensus, that there should be accountability for these gross violations of human rights, the fulcrum would then be seen as closer to that weight of corporate accountability, easier to lift it up. But during the Cold War, it's much further away, and so we have no cases of accountability in Japan, despite the fact that even U.S. veterans were making claims to be for trials in the U.S. for slave labor during the war in the World War II in Japan. So this kind of metaphor is what helps us explain why we see corporate accountability from below. That this can be, under certain circumstances, we can lift up this weight of corporate accountability when these factors are in place. But let's think about the role of global pressure. I'll move to the next one. So we can say that there has been, up to now, very little pressure that's coming from the global arena or the internet, very little international pressure. But we're starting to see some change in that way. And this touches on some of the points that Alison brought up in her presentation. First of all, there is an effort to develop a treaty on business and human rights. Right now it's in a draft stage, but there's a possibility that there will be a treaty law regarding the responsibilities of economic actors for human rights abuses and other environmental and other abuses. There's also more movement on the part of foreign courts, not the U.S. court, but we could talk about what's happened in the Supreme Court in the U.S. in terms of the possibility of using the Alien Tort Statute. But other courts, even the U.K. courts, French courts, have started to think about possibilities of holding businesses accountable if they appear for human rights abuses, if they appear on the British Stock Exchange, right, or the French. So they don't have to be UK companies. As long as they are listed in the stock exchange, then they can be held accountable under these proposed laws. Haven't yet passed. So this is a sign of change, that even the creative efforts of thinking about this shows some recognition of these rights violations and the need for some kind of global governance with regard to them. We've also seen regional courts, the Inter-American Court, the Inter-American Commission on Human Rights has been involved in a number of these cases, particularly when they involve indigenous communities in Latin America, but also in there's a case in Afro-Colombian communities where the Inter-American Commission also became involved and added that pressure, in this case, that allowed the Afro-Colombian community to win this case, and the head of this company is now serving time in prison. The African Union has the Marabou protocol, which is also a way to start to consider how to bring companies accountable through the African system of human rights as well. So there's the beginning of this context for change. We could say that perhaps with more movement in this area, we would push the international fulcrum or context closer to that weight of accountability. That's why that arrow is pushing it. Now it's more in a neutral position, but it could be pushed closer to that weight. And we also might see more neutral international pressure groups beginning to put the pressure on the side of victims to fill this victims gap and help add that weight to lift up corporate accountability. I think that's my last slide. Okay. And so thank you for that, and I'll fill in all the gaps, not the victims gap, but all the other gaps in our Q&A.
Yes, and I want to point out, sorry, I just wanted to point out I am familiar with some of the cases in the 2020 book, but I haven't had the opportunity to look in the 2022 book. I have all kinds of questions myself, and so we do have those two books and the database that they reflect for those of us who are interested in following up on these, right? So do you want to repeat?
As far as I know, there are only two books that have been produced yet of the new one, and I have them both, but gave one away. So we're trying to figure out where these are in the system. It's an OUP book, so it should be available in Oxford, but we're still trying to find out when others might see it. Right? But I can send you secretly the PDF if you would like to see the PDF of the book.
I just wanted to make sure we all had access somehow, to follow up, because this is really interesting. Thank you. All right, now for something completely different and yet related.
Yes, thank you. That was fascinating, Leigh, and thank you, Alison, for the invitation and your presentation. Your book, Global Good Samaritans, influenced me very much back in the days when I was a student. And studying human rights foreign policy. So what I'm going to present to you today is this crossroads in human rights and global governance. Following Alison's proposal, I will focus on the UN human rights regime, which includes the instruments, legal, the law and norms, but also the institutions like bodies in different mechanisms. So following Alison's proposal of this crossroads idea when the framework of the future of human rights, we can see that there are things that are expanding. So on the good side, we see that there are innovative mechanisms in global governance, and the one I will focus on today is the Universal Periodic Review, the UPR, where there is also the development of new norms. Very briefly, one example is sexual orientation and gender identity rights, which started in the UPR before they made it to the Human Rights Council. States started mainstreaming them in their recommendations in the UPR. So sometimes these spaces, dialogical spaces, provide a forum for states to bring up new agendas of human rights. But we also see some contractions, as Alison proposes. And in the backlash and dehumanization, we also see backlash and challenges to international institutions more and more these days. We know probably that was very popular, the crisis in the Human Rights Council when the US left in June 2018, that made it to the news, right? Like some big events. And the US left accusing the council of being a cesspool of political bias. So usually much of the criticism towards international institutions these days comes in the form of allegations of politicization. And I will say more later on how there is still a lot of conceptual vagueness around it. But also on the normative side of things, we see states mainstreaming rights that we might also want to push forward, like SOGI. We also see some states pushing more conservative agendas. And Russia was one of the leaders of an agenda on the protection of the family and traditional values. And they try to frame it as a human right, and they push it. So we have to pay attention to what states are promoting there, because there are also agendas that try to contract human rights. So a question at the crossroads of these two things in the sphere of global governance is there politicization in the UPR? And I put it quote unquote because I will clarify on the concept and my proposition about it. So what I'm going to present to you today is, I'm not a senior scholar, I'm an early career researcher, so I don't have books published yet, but I have a book manuscript based on my doctoral research, and hopefully it will be published, and it's called Reviewing Human Rights, Promotion, Contestation and Politicization in the UPR. But I don't want to assume that everyone knows what the UPR is. I'm happy to talk into more detail about it in the Q&A. But just in a nutshell, the UPR is a peer review mechanism which started operating in the UN in 2008, so it's relatively new. And in that mechanism, all UN member states make recommendations to each other about the human rights laws, practices, and policies under their jurisdiction. So the way it goes is states present a national report, which is considered along a summary of stakeholders' reports. It's like NGOs send their submissions, and the UN summarizes recommendations in a 10-page report. And then there is a third report that is a compilation of UN information, what different bodies in the UN and agencies have said about related to human rights in the state that is going to be under review. And that state then sits for a 3.5-hour interactive dialogue where they present the human rights situation in their country. They go like at the high level, officers go into Geneva and they sit there, and all the other states can take the floor and make recommendations. So in this sense, the UPR is a very innovative mechanism, at least in the human rights area. One of the main innovations is that it takes place at the horizontal level. We know a lot about monitoring states or trying to enforce human rights from above and below, from international organizations and from domestic civil society. But in the human rights area, it's the first time that states are constantly facing the criticism or the review from their peers. And when I say it constantly, it's because the UPR takes place in a cyclic manner. It's a calendar of 4 years, and every state sits under review every 4.5 years. So by now, it started in 2008, 3 cycles have been completed, and the 4th one starts in November. So and that's how I call it, that it provides a horizontal pathway to impact, which is innovative in the human rights system. So the UPR epitomizes cooperative approaches. Like in human rights, we know a lot about naming and shaming and economic sanctions, but there is research that shows that sometimes these cause the adverse effects, or they don't even cause the desired effects. So looking into more detail at what happens in the UPR can represent the future of global governance at the crossroads of human rights. So what makes the UPR so special is that it is designed based on principles of universality, equality of treatment, because everyone sits under review, everyone is allowed to make recommendations to others. It's also based on international cooperation and dialogue, because the state under review then has to respond to the recommendations made, either noting or accepting them, and in 4 years they have to account for what they've done about how they've implemented the recommendations they've accepted. So states feel that they are all on the same ground. Finally, I argue that the UPR is a forum that it is used by states to define the meaning of norms, to advance agendas that we might like or not like, but there is a space for promotion and contestation of human rights to define what human rights are, and it's used to socialize states because of its dialogical power. So then let's look at the negative side and this question of, is there politicization in the UPR? And as I said, there is still vagueness around the concept. I've reviewed the literature and also how it's used in UN documents. And the word is very heavy loaded because these allegations of politicization, they are not new. Like what happened in the Human Rights Council in 2018, it's a deja vu of what happened in the early 2000s. The Human Rights Council was created in 2005-06 because the former Commission on Human Rights was had received so many criticism of politicization that led to a crisis of credibility and effectiveness that that led to its demise. So the system had to be changed. The institution wasn't effective anymore. It was receiving so much criticism that something needed to change. And Kofi Annan made the proposal, and states negotiated over a couple of years, and they came up with the Human Rights Council as a new institution to replace the Commission, most of its functions, and they created as an innovative thing the UPR, trying to tackle those allegations of politicization. In the literature and in UN documents, politicization usually means selectivity, partiality, bias, double standards. But the way the word is used is also very politicized. It's very manipulated. So the definition I use is that politicization is instrumental activism that reveals an inconsistency of behavior that entails selectivity, partiality, bias, and double standards that are not informed by human rights issues. Why do I clarify this at the end? Because I think, and probably Alison agrees, having seen the foreign policy of human rights, you mentioned why would states invest their limited resources and time in promoting human rights or in advancing human rights agendas. There needs to be some selectivity, like in which agendas states are going to advance. And there is room for normative behavior within selectivity, some genuine concern for some rights as opposed to others, or prioritizations in the agendas. And that's not necessarily something that we have to taint as problematic. That is my take. That's why I clarify that there is selectivity, partiality, and bias, double standards, more informed by geopolitical issues or trade, friendship, rivalry that is not necessarily related to human rights. So I argue, in my experience doing fieldwork in Geneva, interviewing 40 diplomats from different countries, a wide variety, that there is little politicization in the UPR. It's more the exception than the rule, and the way states define it is more to do with states making an excessive number of harsh recommendations, and there you can see it if you are on the ground. In some observations, I was sitting at the gallery for visitors there, and although I don't speak Russian, when Russia was reviewing the US, they had 1 minute to talk, and the person wasn't even breathing. It was like ta 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 ta, and you could say that they were ordering and counting. And then when I saw the translation, it was like 9 recommendations in 1 minute, whereas the average is 2, right? So an excessive number of recommendations. Something's going on there, because usually when the states speak, they say like all these diplomatic things. We welcome the delegation and so on, and we want. So if they don't do this introduction, they go straight to the recommendations. Something's going on there. But those are some few exceptions, actually. And then there are some confrontational recommendations which are perceived as not going with the essence of the mechanism. I said the UPR is a cooperative mechanism. So when states use it to confront each other, to talk about things that are not directly seen as related to the essence of the mechanism, they are seen as what they also call red line recommendations. They are crossing the red lines of politics. So finally, I think a problem with the current literature looking at politicization in the UPR is that much of the theorization and analysis is done based on the wrong assumption that the UPR is a naming and shaming mechanism, which is not. I argue that it's not. It wasn't designed as such. on the perception on the ground, states don't see it as a naming and shaming mechanism. There are few instances of that, which is what we could call this politicization, because part of what is the essence of naming and shaming is putting a state on the spotlight. But in this case, everyone knows that they are going to be on the spotlight, so they are expecting to receive recommendations. So it's not properly criticism per se. So the theorization needs to refine that basic assumption. Another thing is that states can use how they make recommendations and how many they make, but they can also use silence as politicization. And I brought some examples in case they want to see on how Lebanon has admitted of using it as a way of not sitting in Israel's review. They argue, like, if I sit there, I'm recognizing it is a state, so I don't go to the room, and that's my way of protesting it. So they use silence instrumentally. They don't make recommendations to states that have diplomatic relations with Taiwan, and they said that, and you can see in the network in a visualization that I have. And that is also under-theorized in the literature, and I can come to fill that gap too. But yeah, happy to speak more about the UPR in the Q&A, because I know many people don't know about it, and I think it's a very interesting a promising mechanism. Not that it's going to save human rights, but it is an innovation that can be a model for our new modes of socializing states into respecting and protecting human rights. Thanks.
Did you want to do the one more?
You want to show the network? No. And this is what I said about the silence, the examples, and there you can see the network of China. The red one is the ego network with China in the middle and the recommendations they've made. And the blue network is Taiwan and the countries with whom they have diplomatic relations, and you see very little overlap between those. Yeah? I don't know if that's clear. The green ones are isolates. So, yeah, I'll leave you with that.